So good morning, everyone, and welcome to today's session on the gift clause and the recent Schires decision and discussion of the future of economic development in Arizona in light of the court decision. I'm Mike Rankin. I'm the city attorney for the city of Tucson, and it's my pleasure to be able to introduce the speakers today for our session. We're going to have a couple of breaks along the way. So we're going to start with a first session that features two speakers, and then we're going to shift gears a little bit and have a discussion about the history of the gift clause and in Arizona and litigation surrounding the gift clause. And at the end of it, we're going to have an opportunity for a roundtable discussion and answering questions that you might have that come up during the presentations. As you know, this is a webinar format, so you can see the presenters, but the presenters can't see or hear you. But we do have, if you're familiar with using Zoom, a way for you to submit questions into the Q&A or even into the chat features. And Nancy Davidson, the attorney for the general counsel for the Arizona League, and I'll try and keep an eye on those questions so that the presenters have a chance to respond to them as we go through this. But the first session before we break is going to feature two speakers who will discuss Schires and its implications and a case arising out of Pima County. So let me introduce them. We have, of course, Cameron Artigue. Cameron has been with Gamage and Burnham for 30 years now, doing litigation and zoning, land use, and real estate. Cameron has also taught the zoning class at the ASU Law School with Grady Gamage for the past 15 years. He litigated the Turkin v. Gordon City North case and has advised many municipalities and private developers alike on gift clause issues. And then after Cameron goes through the Schires case, we're going to hear from Regina Nasson. Regina is the Deputy Director of Economic Development for Pima County, a position she recently moved over into after 17 years as a Deputy Pima County Attorney. At the Pima County Attorney's Office, she served as the supervising attorney of the Business and Transactions Unit, as well as serving as the office's Chief Ethics Counsel. After law school at the U of A, Regina clerked for 1 year for Justice Martone on the Arizona Supreme Court, and then was with Snell and Wilmer for 7 years. She also has authored many appellate briefs and provided an amicus in Schires. She recently successfully defeated a lawsuit filed against Pima County by the Goldwater Institute, and you'll be hearing about that today. So, Cameron, take it away.
Thank you, Mike. Good morning, everybody. This is truly a brain trust on the gift clause. There's a lot of good nuggets of information for you as we proceed this morning. I was sort of originally invited to provide the private sector perspective on the gift clause, but there is really no division of interest here. Obviously, we are sitting across the table from municipal entities as we're negotiating deals, but once a deal gets inked, then we're pretty much on the same side should somebody choose to challenge an agreement under the gift clause. So the advice I'm going to say today, the thoughts I'm going to share today, are really no different than what I would say in advising the private sector. Okay, I'm going to dive right into this. Nancy, if you just want to go to the next slide, I'm going to go fast and share lots of thoughts. There are two holdings to Schires versus Carlap. Holding number one, which has received less discussion, is the no deference to elected officials. The court changed pre-existing law and said we're no longer going to apply an abuse of discretion standard. We're going to make a de novo determination on sufficiency of consideration. This was not foreshadowed in the briefing. This was not foreshadowed in the questions presented that the court framed. This was not necessary to the disposition. This is activism. by the court in changing the deference that is due or not accorded to elected officials. I think, no, obviously this makes it less of an uphill battle for someone who wishes to challenge an agreement, but I think it may have a more subtle impact on how these cases get litigated. Heretofore, an abuse of discretion standard has kind of teed up these gift clause cases as summary judgment cases, because you just attach the agreement to the cross motions and you say, hey, judge, there's no parole evidence. Here's the agreement. You tell us, is it legal or not? And it's a summary judgment case. Once you change it to a de novo standard of review, you're probably not going to be using the same expert reports that were assembled for counsel. You're probably going to be litigating it more like a personal injury case or a condemnation case, where you've got experts in litigation assembling valuation models. And in that context, you're going to have experts, and Regina will talk about this in her case, who disagree about present value calculations, about accounting assumptions. And you'll have one side saying, in my opinion, the city's getting $4 million in value. The other expert says, well, in my opinion, the city's getting $700,000 in value. And you could wind up trying these cases. And adequate consideration may, in fact, be a fact issue. Whether that's a question of fact or a question of law has not really received a lot of attention. So I think these cases will wind up getting litigated perhaps differently due to this change in the standard of review. And it's going to affect, again, the types of studies and analysis that cities are going to need to assemble. When you've got an abuse of discretion standard, you can rely on the engagement of the consultants that was presented to the council, and it's a nice presentation and it's nicely bound and it provides a good evidentiary basis for the council to have made its decision. But you need something different if you're in court defending something in a de novo way. Okay, now let's go to the big show. Nancy, next slide. Let's go to holding number 2, because this is what everyone really wants to talk about. What counts as consideration? Did Schires versus Carlat change or not change Turkin versus Gordon? In Turkin versus Gordon, we spent a year and a half debating indirect versus direct benefits, what counts and what doesn't. The ultimate holding of that case was the invention of Justice Hurwitz. It was not advocated by the parties, and it was not something discussed at the Court of Appeals. The Supreme Court holds that what counts as consideration is the promises that are made as part of the contractual performance by the private party. If it's something that is promised on which a claim of breach could be predicated, then it is consideration. If it's just something out there, you should buy this car because you'll be popular if you buy the car, that doesn't count as consideration. So what we have said for the past dozen years is best practices is to make whatever promises the private party is going to make, try and build them into the very structure of the agreement, so that it is a sort of condition of the incentive agreement. So if you're going to say, hey, this is going to create jobs, make it a performance threshold. Say that this is earned if this number of jobs is created. Okay, the question for today is, did Schires change that? And there are two very different viewpoints that have emerged. Viewpoint number one, which has been expressed by a bunch of lawyers I respect, is that nothing changed. It's business as usual. What supports this view of the world is that there is language in Schires that says, hey, the university didn't promise any particular economic result to Peoria, implying that had such a promise been made, it would have changed the case. There's nothing in the Schires opinion that disavows or changes the Turkin versus Gordon analysis. We know the Supreme Court knows how to do that because they were quite explicit in changing the law on abuse of discretion. You don't see that on what counts as consideration. So there is a point of view that Schires is really just a lesson in be careful about writing your agreement, because the university didn't make any explicit promises to Peoria. And had they just had some smart Arizona lawyers vet the contract with an eye towards Arizona law, it would have been a different case. Okay, version number 2, or perspective number 2, is that no, Schires changed the law. What supports this point of view is other language in the opinion that says, if you allow a private party's promises to conduct its private business to count as consideration, it would eviscerate the gift clause. And I would point you back to the question presented on which the court granted review. The Supreme Court wrote its own questions when it granted review last year. One of them was, does it count, does a private party's promise to operate its own business count as consideration under the gift clause? That's not a quantitative question, that's a qualitative question. Can it ever count? And where you see this manifest itself in the opinion is, of course, the hamburger stand, where the court says, if you let a hamburger stand say, hey, we'll come serve hamburgers in your jurisdiction, and that'll be great, you can't let that sort of promise count under the gift clause. This is new. It's not in Turkin versus Gorton, and it resonates with the question presented that presumably the court set out to answer. Okay, why is the opinion ambiguous? Why have they dropped this in our lap? One theory is that the court was just careless and didn't write a very careful opinion. I think that is absolutely false. I think that the court is a much more careful institution than that. This is speculation. What I think happened is that all 7 justices agreed that Peoria should lose. So the result is unanimous, and there's no need to divide into majority and dissenting opinions when you all agree on the result. But within the justices, you had some who said, hey, Peoria loses under Turkin versus Gorton. You had some other justices that said, let's change the gift clause analysis. And some other justices who said, well, do we really need to do that? Let's save that for another day. And a court doesn't want to divide into concurring opinions if it doesn't have to. And so the optimal solution is to write an opinion where all 7 justices can sign on to it, and each of them sees something where they say, yeah, this is what I need to sign on to the opinion. And so that's why you get this sort of ambiguous opinion that kind of punts for another day what counts as consideration. So if somebody out there, somebody later this morning says, I know the true and correct meaning of Schires versus Carlat, don't believe them, because I think it is ambiguous for a carefully considered reason. Okay, next slide. This is a sort of interlude. This is my beef about Nancy, pass holding number 2. This is just my observation on the inaptness of the procurement model, starting with Hurwitz in the Turkin case and continuing in Schires. The court has tried to conceptualize the adequacy of consideration as a purchase and sale situation. And that makes a certain amount of sense. All of us buy things. Not all of us have sat as an elected official on a city council and approved a development agreement. So when the court is conceptualizing, gosh, the law here is about a government entity getting its money's worth, how would I think through that? What comes to mind is a retail purchase, a procurement model. And if you're buying a fire truck, that's the model you want. But my misgiving is that that model is completely inapt when you apply it to the decisions that elected officials actually make in the real world. Here's my example. Real world example, names changed to protect the innocent. An industrial use is located in the county on the border of a municipality. It's going to be a big deal. The industrial use can develop in the county. Okay, they can get the entitlements. If they develop in the county, the city can't tax it. The city can't do the dedications and exactions. The city can't get the zoning stipulations. The city can't do the design review. And so there's a lot of reasons why the city might want this use to be annexed. And the owner says, hey, we're happy to be annexed. We'd love to be annexed. And you, city, if you want to do the design review and tax it and control the landscaping and the traffic and everything else, we're happy to sign an annexation petition. What can you bring to the table to bring us into the city? Now, that happens. This is a real world example. If you're the city, that is absolutely not a purchase and sale situation. If the city says, yeah, here's a certain dollar amount of incentives to bring you into the city, how on God's earth are you supposed to analyze whether the city is getting its money's worth? How is any appraiser supposed to put a dollar value on the city's exercise of its police power in lieu of the county controlling that development? It's a completely artificial enterprise when you force it into this procurement mold. And Justice Feldman says in Wistuber, courts are supposed to take a panoptic view of the facts. What this procurement way of thinking does is it forces courts to look through a paper towel tube and say, we're just going to force everything into a kind of purchase and sale construct, even when that's not at all what's going on in a lot of these agreements. Because what drives a city is things that are not being bought off the shelf. A city doesn't buy an expansion of its regulatory jurisdiction, and a private party doesn't really sell that. So anyway, that's my beef on that. Now I'm going to do a big pivot to a menu of steps to mitigate and avoid Schires versus Carlyle issues. So Nancy, let's go to the next slide. Let me just run through these. The toolbox for responding to Schires. Number one, do not be a hamburger stand, by which I mean agreements need to hedge against both readings of the Schires opinion. By all means, continue to incorporate into the contract as much of the contractual promises that can be incorporated to satisfy the Turkin versus Gordon. You should have been doing that all along. But you need to have a response to the hamburger stand talking point. So somebody can't say, well, the city is just paying this private sector entity to come here and open up shop, and you can't do that. That's the hamburger stand. So what needs to happen is the private side needs to make some promise that is over and above that which naturally inheres in its operation of its private business. You can't just say, hey, our hamburgers are delicious, you're so lucky to eat them. You need to say, we're going to employ this number of people. We're going to have a program for residents of the municipality to get free milkshakes on Tuesdays. We're going to give preference to local people in hiring. We promise to stay open for this length of time. We promise to support youth sports teams in this regard. So, you create valuation questions, but you need to do something so that you can say convincingly that you're not a hamburger stand, or that the private party is not a hamburger stand. Number two, use infrastructure. Really the best solution to Schires versus Carlat, the best consideration that was not used in that case is municipally owned infrastructure. If a city builds whatever, streets, sewers, anything else, and then owns it, it's hard to argue that not getting anything out of the deal. Under the very old case law from the 1970s, it doesn't really matter that a private party benefits from the new water line. So, building infrastructure that supports a private development is probably going to be sufficient consideration under Schires versus Carlat. Another aspect of this is going to be you don't have to insist on every possible exaction and dedication. You can't waive impact fees because that raises issues under the impact fee statute. But nothing in the gift clause requires the city to be as aggressive as Nolan and Dolan permit them to be. So, there is some ability there to use the dedications and exactions process to kind of level things out. Finally, there might be a possibility for a private party to construct infrastructure and dedicate it. And I'm thinking here about something like a parking lot or a parking structure that is built and paid for by a private party, but dedicated to public use with some kind of use agreement coming back, so that at the end you can say, yeah, the city got this parking garage out of it. They own it. And that's going to count as consideration under Schires. Third point, Cotterman versus Killian. This is the name of an old Supreme Court case from the 1990s. It had to do with, it was a challenge to a school tax credit. The argument was that giving tax credits violated the gift clause because it was a gift to private schools. The Supreme Court says, no, that giving a tax credit cannot be a gift. And the line from the opinion is, you cannot make a gift of that which you do not own. So think about this in terms of a statement of cash flows on a financial statement. The gift clause is solely concerned with the expenditure side of the statement of cash flows. Those are, or could be, gifts. The revenue side of the financial statement is just not a concern of the gift clause. And that's what Cotterman versus Killian says. So I think that if you were waiving plan review fees and foregoing other possible revenue, that's not a gift clause problem. This becomes a big issue in Giblet, because a challenge to the giblets under the gift clause is all about kind of a loss of revenue. Mary O'Grady can talk about that some, but my view is that the tax code, it may be good policy, it may be bad policy, but it can't be making gifts. If Arizona legislature goes to a flat tax, you can have different views about that, but it's not making a gift within the meaning of the gift clause. So remember that. Next point, center of the herd. There have been 12 years we've been thinking about this. There have been thousands of cases, thousands of deals approved over the last dozen years. I think less than 12 have actually prompted a lawsuit. So there is a great safety as a practical matter in staying with the mainstream and not operating on the edge of the herd, because that's who gets sued. The secret sauce of the Goldwater Institute is case selection. They select cases that they are likely to win. So they select cases that are strong on the merits, and they also select cases that can be explained in a single sentence, because they need to pitch them to their donor base and to their own supporters and to the press. So that's why, in Schires versus Carlisle, it was, well, you can't pay a university to come here and operate as a university and get nothing back. That's an elevator talk. So if you can keep your case not as strong on the merits, Goldwater doesn't like to lose any more than anybody else. So if it's a little bit stronger on the merits, and if your case is complicated, it operates as a deterrent against getting sued. And this is my next talking point. I hate it, to advocate complexity, because so much of what I do is about distilling things and simplifying them. And it just seems crazy to say, intentionally make your deal complicated. And I'm not advocating that, but it's a thought to keep in mind that it is like the needles on a cactus. When you're reading an agreement and you have to read it 4 times to figure out how the hell it works, it's just a less appetizing gift clause challenge. So keep that in mind. Finally, Turkin, footnote 4, Turkin versus Gordon says that the gift clause doesn't apply to gifts. We spent an enormous amount of time in that case talking about, what about the Phoenix Zoo, which operates on $1 a year rent? What about the Phoenix Symphony, which doesn't pay any rent at all? Are those gifts? People said, well, those are 501c3s. Well, the Internal Revenue Code is not part of the gift clause. But what the court said is, well, those aren't commercial situations. And if you're supporting a social program, something like that, the gift clause doesn't apply. Oh, I skipped over special district immunity. This is just kind of this thought is not fully baked, as Benjamin Braddock would say, but it's out there. In the Constitution, all special districts are expressly exempted from the gift clause. All your fire districts, your irrigation districts, all your tax levying public improvement districts are explicitly exempted from the gift clause in Article 13, Section 7 of the Arizona Constitution. I don't know why. Maybe somebody can tell me the history there. But those districts there is no gift clause challenge. Now, I don't know how you would structure an incentive agreement to be where one of those districts is the counterparty, but somebody will come up with a bright idea to do that. And that is a way to eliminate any gift clause issue. Finally, and then I'll be quiet, the legislative change, when you're explaining this to non-lawyers, this is the Constitution, obviously. A lot of people have the initial reaction of, oh, let's run a bill to fix this. Well, not so fast. You can't really fix this with a bill. But what you could do, well, I've talked about this a lot. The bright idea I've got is to make gift clause challenges subject to the notice of claim statute, and perhaps a even faster and stricter notice of claim statute. They're not subject to notice of claim now because it's not a claim for money damages. And as you know, the statute of limitations is currently a year for claims against municipalities. What I would say is make it like annexation, where there's a one-time 30-day window for legal challenge. And if you don't file that lawsuit within 30 days, you are forever barred. Because the private sector can wait 30 days to see if something's challenged under the gift clause. The private sector cannot wait a year after a deal is approved to say, well, let's just wait and see if somebody files a lawsuit under the gift clause. So if this becomes a practical problem around Arizona, something to think about for future legislative sessions would be some kind of time limit on making a gift clause challenge. And that's all I got. Thank you, and carry on.
Okay, so is it my turn?
Oh, I'm sorry. Yes, I should have kicked it to you, Regina. Yes.
We have questions, but we'll wait till after. Perfect. And I was going to, on that notice of claim, I'm curious about what you think about the Board of Regents, that decision at the AG. They said that he couldn't sue gift clause, and I might be misremembering, and because he didn't file it within the notice of claim statute of limitations, but I'm going to cut out.
Okay, so hi, everybody. I am going to talk about a case that involves Pima County, and it's one that's actually ongoing. This was a case that was brought by the Goldwater Institute, of course, with some taxpayers as the named plaintiffs, against Pima County in 2016, after the county did an economic development deal with a company called Worldview Enterprises that was developing and starting to commercialize some interesting technology, which was it was a balloon that would go up into the stratosphere. So it's a super high altitude balloon technology that had a number of different applications. Goldwater, when they talk about it, like to focus on the space tourism aspect of it, which really is not a big part of it anymore. They have other applications. So the Board of Supervisors, and just so you know, so we won in the trial court, and there is an appeal going on now. Goldwater filed a notice of appeal in the Division 2 of the Court of Appeals. So that's where the case is at this point. The county doesn't mind if I talk about it because we've been winning so far. So, the Board of Supervisors in January of 2016 approved this deal with Worldview. They did it under their economic development, their economic activity authority under 11-254-04 that allows boards of supervisors to expend money for economic development purposes, and economic development purposes is defined very broadly, but also specifically includes leasing and conveyance of real property. So rather than following the normal leasing or conveyance statutes for county property that would require an auction and a minimum bid, the board proceeded directly under its economic development authority. Goldwater sued. The case really kind of got cut up into three sequential parts. The first one was the issue of whether the county properly followed the economic development statute without following the normal leasing statutes. We lost on that in the trial court. We won in the Court of Appeals. And I mentioned that, I know we're here to talk about gift clause, but I mentioned it because I think it was an important decision, and I think it was a big win. Cities and towns, you have a counterpart of this statute in Title IX that again talks about expending funds for economic development activities. So you can do a deal under that without having to go through whatever other procedural obligations and minimum prices that you might have in other statutes. So that's kind of cool. The middle part of the case involved procurement issue, and it doesn't really matter. We ultimately won. But again, now we finally got to the third part of the case, which was the gift clause. We had kind of a little mini trial in the trial court on that during COVID. We basically submitted exhibits, which were primarily a lot of appraisals and things like that. And then we had argument, and the court issued a very thorough opinion, like 25 pages, and Pima County won. So I want to talk a little bit about some of the issues in the cases and in the case, and what I think could conceivably happen as we go forward. And I have done a bunch of amicus briefs over the years in Turkin, in the Phoenix Law Enforcement Association case, and the Schires case on gift clause issues. And so it was actually kind of fun when Goldwater sued the county. This was a deal. I'm primarily really a transactional lawyer. And so I helped put this deal together with Worldview and advised the board about it. And it was an interesting development when Goldwater sued us. And you know, Cameron was talking about Goldwater picking its cases. It always seemed peculiar to me that they would pick this one, because I really felt like it was very defensible, and it has been. I mean, we'll see what happens going forward, but I thought it was an interesting choice. So the deal that the county struck with Worldview is that the county would build a facility for Worldview on county-owned land, and it would essentially lease sell it to Goldwater over a period of 20 years. And the lease set the rental rate that escalated every 5 years. So it was a little backloaded. It was lower on the front end. It was higher on the back end. And it was going to be a 135,000 square foot facility. And then at the end of the 20-year term, after they had paid almost $25 million in rent, they would be able to purchase the building for $10. We also did an operating agreement with Worldview that the county built on adjacent property a giant balloon launch pad, which is, I always call it a giant tetherball court. It's this huge circle of concrete. And we kept that as a public facility. So Worldview agreed to operate it on behalf of the county. They would be able to use it, but they would also make it available to other users. They could charge an administrative fee to other users, but only in an amount sufficient to recapture a proportionate amount of their actual operating and administrative expenses. So they couldn't make money on it. The county, it was going to build the facility and it would spend up to $14 million. And then again, it would get that almost $25 million back in rent. Worldview also agreed to hire a certain number of employees and pay them certain minimum salary amounts. So Goldwater sued after we made that deal. The deal was done in January. They sued in April. And like I said, they alleged those three components, but we'll skip forward to the gift clause for now. So the county's argument, our argument as to why this passed gift clause challenge was, first of all, you need to compare one point in time, right? You have to look at the market value of what's on one side of the ledger with the market value of what's on the other side of the ledger. And in order to do that, you need to compare values that are apples to apples rather than apples to oranges. So we looked at it in terms of what is Worldview getting? They're getting the facility ultimately, right? What are they paying for the facility? So we looked at the fair market value of the facility, and we looked at the present value of that stream of rent payments. The fair market value, and there ultimately wasn't a whole lot of disagreement, by the way, between the two appraisers for the two sides. So fundamentally, everybody ended up agreeing that the fair market value of the facility at the beginning of the lease term was $14 million. The county actually spent about $12.9 million. The fair market value of the dirt, the land, plus the actual cost of constructing the building was actually $12.9 million. Arguably, I think under a gift clause analysis, when you're looking at what the county is spending, I think you could make a good argument that you should really, in terms of what the county is providing, that you could use $12.9 million. But Turkin says fair market value, so we went with the fair market value of the building, which was $14 million. On the other side of the ledger, the county is getting a stream of rent payments. Our appraiser did a present value analysis of that using a discount rate that a private investor would use. So it was a little, fairly steep discount rate, and came up with $11.7 million. And we said, look, gross disproportionality. 11.7 is not grossly disproportionate to 14. It's actually about 85% of that $14 million. Even when the county follows statutes for selling property off to the highest bidder, the minimum price is 90% of appraised value. So whatever grossly disproportionate means, it surely doesn't mean 84% of appraised value. Goldwater's argument, they tried to throw a whole bunch of things in on the side of the ledger in terms of what Worldview is getting. They wanted to throw in the value of the launch pad. Again, the county argued that's a public facility. They don't get ownership of it. They only get to use it. They don't get to make money on it. If the county was operating it for users, it would just be more of a liability than a true asset, as public infrastructure tends to be. There's no gift there. The court agreed with that argument. Goldwater also tried to make an argument, which I don't know if they'll try this again. They tried to argue that somehow, because this looked like a financing transaction, which it fundamentally was, right? The county was financing the building, that somehow it was therefore per se unconstitutional under the gift clause, because they tried to separate out the give or loan its credit in aid of phrase from the make any donation or grant. And they said that, oh, it's just per se illegal if it looks like some sort of credit transaction. We responded that there was absolutely no support for that. And it would be illogical, because you could do a loan of, $10 and get interest of 100%, and it would violate the gift clause, whereas it's gross disproportionality. On the other side, it doesn't make any sense. The court agreed on that. They tried to look at the rent and say, well, the county their Worldview is getting a little break on the rent up front. We said you have to look at it, the deal panoptically. You have to look at it as a whole, and the county is ultimately getting that full amount of rent. Goldwater also argued that this was somehow unconstitutional because there was risk involved in it. After all, Worldview could default. We said, okay, well, we still own the building, so basically we'll have what we paid for, and we'll have whatever rent they've paid us. So number one, what risk is there? And number two, risk is not an appropriate thing for the court to take into account. That is something for the town council, the board of supervisors, to figure out on how they're risk averse. You can't put that into the calculus. They said, Goldwater argued that they have Worldview has a $10 option, right, at the end of the lease when the reversionary value of the building is still somewhere between the present value of the reversionary value would be between $2 and $3 million. And again, we said that doesn't make any sense. You have to look at the deal as a whole. And both appraisers agreed that the present fair market value of the property contained a present value for the reversion. So you couldn't just sort of try to separate it out and double count things. And the court, again, agreed with that. Goldwater also tried to say that the property tax savings was a consideration that the county was providing, and therefore that was part of it, what it was giving Worldview. We argued no, just like indirect benefits that might accrue to a public entity as a result of a transaction, the tax saving is a savings that arises under law and is a result of the transaction, but is definitely not something that the county is promising or giving. It doesn't count. Again, the trial court agreed with that. So it really came down to this concept, I think, of gross disproportionality. And the interesting thing is we really don't have guidance on that from the court. We've never had a case where the court says, this much is too much. You know, where's the line, right? Where does gross disproportionality lie? We pointed to cases where a gross disproportional standard is applied in determining whether a non-judicial foreclosure sale has to be found invalid. In that case, courts will say even something around, say, 25% of appraised value is acceptable. They will not overturn a sale. So we said gross disproportionality is somewhere more down there. Okay, maybe it's not as low as like 10%, right? But it's pretty far down the scale. It's definitely not 84%. So I know I only have a couple minutes left and I don't want to go over my time. So we are in the Court of Appeals. And I need to find out who's actually handling that case for the county, because this is my baby. So I want to stay involved and make sure it goes well. But I think, and then of course they'll go up to the Supreme Court. They'll file a petition for review if we win. I'm cautiously optimistic, I guess, that we'll win in the Court of Appeals. If it goes up to the Supreme Court, they may just say, we did our gift clause case for this 5-year period and we're not going to take it. Or they might take it and I think address perhaps that gross disproportionality standard. It's a standard that some of the justices do not love. On the other hand, in the Schires decision, the court did reference that standard several times. And I think there are other members of the court who would be very reluctant to overturn longstanding precedent with respect to that. So it may be a matter of them interpreting what it means rather than simply pulling back on it. Goldwater tried to argue as well that economic development is not a true public purpose. I think Schires has once again confirmed that economic development is indeed an appropriate public purpose. So that should be dead in the water. They might argue some of those indirect benefit things like the savings in taxes. I think that's a loser. So like I said, I think it'll be interesting to see whether that gross disproportionality standard is a subject for the appellate courts to deal with. And with that, I think I'm done. Sorry if I spoke too fast. And poor Mary O'Grady, I did an amicus brief in the Schires case, and I kind of teased her because I said, my fear with the Worldview is that it's going to be my case, right? It's going to be the one where they take this and they're so determined to find a gift clause violation that mine ends up being the case that like brings everything down. And so I said, God bless, Mary, I'm glad you're going there first. It's very Machiavellian of me, but.
Well, thanks, Regina. Thanks, Cameron. There have been some questions that have come into the Q&A box by the folks who are attending. And a couple of those questions are about the infrastructure point that you made, Cameron. And I think you can see the question, so I don't know that you need me to read it out to you. I'll let you take it from there.
Hey, Mike, if you could read it just for those who watch the recording or listen,
Sure.
Then they can know the question also.
Matt, that's a great point. So the first question was from Christina Robokova. Cameron, do you think infrastructure will in fact count under Schires if your code already requires the developer to construct that improvement?
Yes, I think it does. I don't think a city disentitles, I mean, a city can't legislate the substantive parameters of the Constitution. And I think a city should not disentitle itself from what counts as consideration by enacting or not enacting its code. So next question. I'm just reading this. Well, if you have a code that requires a property owner to do certain things, such as build half streets or infrastructure, can waiving that ordinance requirement be seen as a gift in violation of the gift clause? I think the answer is no. I think that if you, I think the answer is no. That is kind of on the Cotterman versus Killian. If you say, hey, we're not going to require you to build a half street, that's not a gift. What's strange about this is that, you know, at some point, it's like the gift clause runs up against the takings clause. The gift clause is designed to protect the government against the greediness of the private sector, and the takings clause protects the private sector against the greediness of the government. And, you know, in another courtroom on another day, the Goldwater Institute would be sticking up for private property rights and saying, oh, you can't make them build that half street. That would be an excessive exaction. And so I think if the government says, okay, well, then we're not going to require that half street, you're hard pressed to say, well, then that's a gift. So I think that it's only the outflows of municipal money that fall into the gift clause. I see a question here. Please repeat Turkin footnote 4. Turkin footnote 4, I'm paraphrasing it, but it says that the gift clause does not apply to municipal transactions that are not contractual in nature. And I think that was the court's way. And there's a very old case from like the 1940s where somebody had the temerity to challenge like a, you know, feed the hungry program. And the Supreme Court said, no, you can do that. You know, free food for the needy is not a gift clause problem. And Turkin cites that. And I think that was the way of dealing with the hypotheticals we were throwing at the court about, well, what about, you know, can you give free rent to the zoo? Can you, you know, is the city of Phoenix allowed to give support to the Boys and Girls Clubs? You know, that kind of thing. So that was Turkin footnote 4. How does giving money to the Super Bowl committee viewed? You know, I don't know the particular parameters of giving money to the Super Bowl committee. I mean, I will tell you that, you know, this whole like bringing the Super Bowl to Arizona is, and the sort of wonderful economic activity that attends that is kind of what the Goldwater Institute is on the lookout for. So I think it all gets down to what is the structure of the agreement. That if, you know, if the, and I don't know, but if the committee is saying we're going to hold these events at, you know, at these locations on these times, and it's going to generate this attendance, that's better from a gift clause perspective than just saying, you know, here's some funding support, and, you know, see you in January, and won't it be great?
And I think there could be an opportunity in those circumstances too to tie it to certain things. Right. I mean, there's going to be some public infrastructure stuff that happens around that, not necessarily permanent, but even temporary. And so you may be able to structure it in a way where you're tying it to certain things that would be very defensible.
I think that's a good point. Okay, I see 2 more questions. Expenditure of coronavirus recovery funds implicate the gift clause, or may cities rely on federal guidelines alone? Boy, this is a finely framed question, and I don't know enough about the coronavirus programs.
I will say that my position has always been, and don't ask me to point to a case that specifically says this, but to me, the gift clause is getting at local revenue, right? when we get money from the feds and they say, you shall use it in these ways, right? And they might give us a bunch of different ways, and we could choose how to use it. But nevertheless, I think if we use it in compliance with any of the ways that the feds have said we can pass that money through, I think we're good.
Okay, next question. Can we discuss the Board of Regents case that Nancy mentioned regarding the 1-year statute of limitations for gift clause challenges? Before I talk about that case, there is a 1-year statute of limitations. The Maricopa County Flood District case, or one of those old cases, says all means all, and this applies to all lawsuits. I know of certain knowledge, because I've sat in the conference room at the Goldwater Institute, that they really don't want to file a lawsuit more than 1 year after a deal is approved. There is a memo decision out there, and I forget, but it's recent, where the court applies and enforces a 1-year statute of limitations on a gift clause challenge. So as a general matter, I think you're on pretty solid ground in assuming that 1-year statute of limitations applies. Now, the Board of Regents case involved a particular statute under which the AG is allowed to recoup like improper expenditures of public money. And I sort of drilled down on this case once around the time of argument, but it's not just the general 12.821 statute. There's there's somewhere in the public money statutes, there's something else that cross-references it. And I just I would not be comfortable talking about that right here and now. But generally, yes, I think there's a 1-year statute of limitations on these gift clause challenges. And even Mark Brnovich is bound by that.
Yeah, I mean, the 1-year statute of limitations even applies to like takings claims. So even constitutional claims fall within that.
Right. Okay, what about facade improvements? Is this a gift or a contractual arrangement? Well, gosh, who owns the facade?
This is a thing. So you can actually, the government can purchase a facade easement, something that says, and it's a real property interest, right? It's the ability to say, we're going to give you some money to fix this up, but then you have to maintain it, and you have to maintain it in its original, the way we've fixed it up, the way we've restored it. So I think there's an actual real property interest that the government is getting there, and I think that can certainly help.
Yeah, I mean, there may be, and this is for hardcore real estate lawyers, but there may be some kind of easement in the, conservation easement in the facade that the government can take and say, look, we got a stick for our bundle. And I would not use Turk and footnote 4 in that way.
I wouldn't either, but yeah. we have done those conservation easements.
Yeah. Anything else? No open questions? Nobody? Yeah, anything else you want to say, Regina, or?
No.
I mean, there's one other thought I had, which is that on this business of how the takings clause and the gift clause interact, I mean, and I'm not advocating this, but if you have a development going in and you had a half street that is the way it's done, you would require the developer to dedicate and build that half street. It's completely proportional under Nolan and Dolan. That's the way it works, but nothing requires the government to require that dedication. So, if you said, well, we're going to make you build the half street, and that will require the private sector to spend $500,000, and then, oh, by the way, we love your development, so there's this economic development package we're going to give you that's worth $500,000. The Goldwater Institute might say, well, we're just going to sue over that second $500,000, and what is the government getting for that? And it may be possible to tie the half street exaction and dedication in as part of the compensation for the incentive, or, and now I'm speaking just theoretically, you can get to the same place if you say, okay, we're not giving you any economic incentive. We're just going to use eminent domain to take that half street. We can have it appraised and we can pay you fair market value for it. And that is not a gift. That's honoring private property rights, as you're advocating down the hall. So there is a place here where the gift clause runs up against the takings clause, and how you manage that, you have to handle case by case. Okay, Nancy,
I had one question for Regina. I was curious because in the Schires case, the decision keeps talking about, if only they had put it in the contract, and, and why are we kind of leaving it up to the judges to figure out this valuation? They should have just spelled it out. And I'm curious with the worldview agreement, how did it spell it out, or how was that portion of it, was it specifically, were the numbers specifically in the contract, basically?
I actually don't read Schires as saying that.
Okay.
Because and the court there actually said we will give no deference, right, to the valuation given by the public entity. That is completely a judicial matter. So I think simply throwing numbers into your contract is not necessarily going to get you there. I think it can help. You try to add as many pieces of legitimate consideration in there as you can. You certainly want to have some numbers in your back pocket to back those up. But I don't think simply putting them in the contract is going to be determinative either way. The county, when it did a deal with Worldview, it had a cap on how much it was going to spend for the construction of the facility. The county actually managed the construction very well and came in under that. We had a per square foot rate for rent. The facility ended up being a little larger than we expected, so the rent actually went up, the cost went down, and none of that could be known, right, until it was really completed. So the other thing we did that we didn't even try in our case, because again, we really tried to keep it simple. We did not even attempt to put a value on Worldview's promises to hire a certain number of people and pay them certain wages, because I don't know exactly how you value that. And we really felt like it was going to muddy the case up, and we could keep it simple by looking at fair market value, present value of rent.
I'm curious too, if you set the, this is just an idea, but putting in the development agreement, what valuation method, at least the method that was used in considering the give and take, maybe, or maybe, I don't think the court will care. They'll do whatever they think. But yeah.
And to be fair, I mean, Pima County, and this was established in the lawsuit, we admitted this, Pima County did not do any sort of appraisal analysis. It was more of a back of the napkin. It can't possibly be a gift clause violation to spend, $13 or $14 million and get $25 million back.
Right.
So I think we're going to take a short break here before we go to Mary O'Grady for her presentation. I did want to note that in addition to the Q&A section, there's a chat, and there's been some chatter going on about how the gift clause does or does not apply to a city or locality's expenditure of federal funds. And it references the case out of the Navajo Nation in the 1970s. That's going to be discussed during the third hour a little bit as well. So we can look forward to that. So thanks, Regina. Thanks, Cameron. I think we'll take a little break. I've got 1 minute after 10 right now. So we'll try and start back up with Mary in 5 minutes, if that works for everyone.
That looks good, Mary.
Okay, good.
Sorry, I dropped off for a minute there with a connection issue, but let me quickly introduce Mary if that didn't already happen while I was out. For this part of the session, Mary is going to lead us through the history of the gift clause and the cases over the decades. For those of you who don't know Mary, she's with Osborne Maladon. She argued the Schires case on behalf of Peoria in front of the Arizona Supreme Court. Mary's practice focuses on appeals, civil litigation, as well as admin law. And I think most of you know that Mary is a former Solicitor General for the state of Arizona. She represented the state of Arizona and various public officials in a variety of high-profile lawsuits in state and federal court over the years. And her work, in fact, has included 10 cases that ultimately the United States Supreme Court has heard on the merits. So, Mary, take it away.
Thanks, Mike. Pleasure to be here today. And I know most of the folks are here because they're interested in Schires, but I thought it might be helpful just to sort of back up and look at sort of how we got here. I think that does help put Schires in context. And so I hope this isn't too boring and too much of making you feel like you're back in law school again, but I just wanted to sort of start from the beginning and see how we got here. And I'll say up front, any comments I make today are mine alone. They don't represent the views of any client or anyone else. So just me. And I think those who know me, I'm something of a geek in terms of the law. I like the law and how it changes. I think that's all kind of very interesting and also history. So for someone like me, the gift clause and the Arizona Constitution generally is really fascinating. And I've been dealing with these issues in a long time in a variety of ways on the legislative level, looking at legislation and seeing how whether it has gift clause implications, advising state and local agencies working on AG opinions in terms of how the gift clause may apply in certain circumstances, and you just see how it touches so many different things, and you can really drive yourself crazy trying to think about how it might apply in all the various situations. And as the law changes, you look back and say, well, are these still good law? Is this still good law? Because they don't often expressly overrule things. They just sort of keep moving. So let's go on and talk about the gift clause. And as I said, since we're starting from the beginning, let me see here. We'll start from the beginning. It's been part of our Constitution since we became a state. And so it was part of the constitutional, debated at the Constitutional Convention back in 1910. So we've had it more than 100 years. It's been around, it's been litigated a lot, and we're sort of still figuring it out. Our Constitution, as most of you know, was very much a product of the times in which it was created, included a lot of progressive era reforms, lots of power to the people through initiative, referendum, recall, sort of a distrust of government in many ways, wanting to make sure it's held accountable to the people, not to special interests, and the gift clause sort of reflects that. And it was made in a way that it could be changed in the future by the voters, and they have frequently changed a lot of it, as you know, over the years. So here's the text of the gift clause. And it's in Article 9, Section 7, and what we call the gift clause is really just the part that I've bolded there. There's a lot more in that, and sometimes you'll deal with those issues in client advice, but the gift clause litigation often focuses on the language that I've put in bold. Neither the state nor any county, city, town, municipality, or other political subdivision of the state shall ever make any donation or grant by subsidy or otherwise to any individual, association, or corporation. You might sometimes deal with loaning its credit or becoming a shareholder in certain businesses, but most of the litigation that we're focusing on is on the bolded language. And we've had this bolded language, we've had most of this language since statehood. The only change since 1910 is the final clause that says Let me see, or as authorized by law solely for investment of monies in the various funds of the state. So except for that, this has been in our Constitution since the beginning. So if you were starting from scratch in constitutional analysis, you look at the text. And as you'll notice from most of the discussion we have, we don't really look at the text anymore. We look at the tests that the court has developed because the text itself, I don't know, it's not that helpful and it's changed a bit. So what conduct is prohibited? Or what is prohibited? What is prohibited is a donation or grant by subsidy or otherwise. So it sounds to me like you can't give stuff away, a donation or grant. Not clear to me how donation is different from a grant. And if you go through the exercise, as I've done in my litigation of looking at 1910 definitions and all that kind of stuff, it's not particularly helpful. It's ordinary meaning, and it's still the ordinary meaning. Often in litigation, Goldwater and otherwise will focus on subsidy. It's a prohibition against subsidies, which grammatically it's, a prohibition on donations and grants by subsidy or otherwise. So what do you get from this language? It's also interesting, I'll note, it doesn't actually use the word gift. It uses these other language, but we've always called it the gift clause. And I think the prohibition there is obviously intended to be broad. So who does it apply to? The state, county, city, town, municipality, or other subdivision of the state. So again, broadly applying to government, and who cannot be the recipients of these donations or grants? Any individual, association, or corporation. Now, again, very broad. Corporation, by its terms, it isn't strictly for-profit corporations. It's, seems broader than that. It doesn't mention partnerships, LLCs, but I don't think any of that matters. I think association is broad enough to include most anything. It's interesting that other parts, if you're doing a textual analysis of Article 9, Section 7, use the word company. You see that elsewhere. You don't see that in the gift clause. I don't think that matters either. But it's just, again, a very broad prohibition on donations or grants by all levels of government. It does not apply to government transfers, only government transfers to private entities, if you're just looking at the text. So that's what our founders gave us to work with. This was part of Article 9, Article 9 of our Constitution. I flipped a little too quickly here. It was one of 11 provisions in that constitutional section initially. That whole section is on public debt, revenue, and taxation. Most of the other provisions in Article 9 in our original Constitution actually refer to debt, revenue, or taxation. So the gift clause is a little different. It talks about, spending. It doesn't really talk about, it doesn't use those terms specifically. So I had included one of the other provisions. This is the first section in Article 9, Section 1, that just talks about the power to tax and talks about taxes only being collected for public purposes. And you'll hear more about that public purpose language. Other provisions in this section talk, establish the state's fiscal year, establish a debt limit, specify tax exemptions. You probably deal with that provision some. All of those were part of the original package. The founders, although we had a lot of those anti-special interests, sort of suspicious of government, I don't think they were really, they were anti-debt, with a serious, a rigid debt limit, at least based on the language. They weren't necessarily anti-tax, and they had a tax provision back as part of the original Constitution that authorized, income tax and a whole range of taxes, which for 1910 was not necessarily the norm. So what did our founders say about the gift clause at the Constitutional Convention? Well, really not much at all. There were no big debates. There were no explanations of why this was important. It was included in an amendment, and again, all of Article 9 as part of our original Constitution on taxation, revenue, and debt. Those were all part of a single amendment that were approved with little debate as reported. The amendment that included the gift clause as part of that Article 9 package in its form that it is now was introduced at the convention in November 16th, 1910 and approved on November 19th. And then the Constitutional Convention closed because their work was done on December 9th. So it wasn't, wasn't around a whole long time I don't know what was going on behind the scenes, but in terms of public scrutiny at the convention, it was really, only a matter of weeks that was given public scrutiny. Now, how did the early cases describe the purpose of the gift clause? Because you don't get that out of the constitutional debates. One of the early cases is from 1925. Says the gift clause represents the reaction of public opinion to the orgies of extravagant dissipation of public funds by counties, townships, cities, and towns in aid of the construction of railways, canals, and other like undertakings during the half century preceding 1880. And that's picked up a lot in terms of the purpose of the gift clause. It's really a reaction to this 19th century spending that was occurring. And that language about the purpose of our gift clause is taken from Montana cases that they had an identical provision. So a lot of state constitutions had these kinds of restrictions. So I'm going to move through some of the early cases. And again, this has been litigated a lot over the years. If you go, and some of these are still cited. You'll see a reference to some of these early cases, not just for the purpose, but for some other principles occasionally. Some of the 1920s issues they were litigating, Rollins versus State Land Board. There it was debt forgiveness because the legislature had, some people had been loaned money and the legislature decided they weren't going to make them pay it off. And so the question was that a gift violation? A gift clause violation, and they said it was, that you couldn't just forgive a debt for no other reason than the inability of a person to pay it. It's a donation, a pure and simple gratuity, unsupported by any consideration, moral or legal. So you do see, the phrase consideration there that we see in the later cases, but it's really kind of, is this a donation? It's just a donation, a pure and simple gratuity, which is where they focused. When they talk about consideration, moral or legal, some of the early cases talked about a moral obligation being sufficient in the gift clause context. I wouldn't go there anymore. One of the other early cases, the Day case that I cited, because it talks about the purpose. There they decided it doesn't apply to irrigation districts because irrigation districts aren't dealing with monies that are general tax revenues. And Cameron mentioned one of the constitutional provisions we now have that makes it very clear, because there was a subsequent amendment that explicitly exempted the irrigation districts and some other special districts from the gift clause. But back in the day, that was something they were litigating to figure out how it applied to special districts, because based on its language, it did. One of the other early cases from the 20s, Tombstone v. Messia, that you'll see a lot, and that actually is a tax case, a tax clause case under that Article 1 and Section 9 about whether an ice house serves a public purpose. And again, you'll see that cited a lot over the years. Jumping ahead to the 40s, more litigation again that you'll still see cited. The Humphrey case is one. The slum clearance didn't violate the gift clause because it serves the public good and the general welfare. It's not a gift or loan to anyone, but an expenditure in the interest of the general public. And so there, like a lot of the early cases, it really focuses on public purpose. And if it served a public purpose, it was okay. And there wasn't a lot of, and that was really the focus of the analysis. There wasn't an analysis of the numbers, as you might see now. Veterans housing, I don't know who chose, I think this was not something that Goldwater would probably pick to challenge today. Veteran housing did not violate the gift clause. And then the Municipal League, what is now the League of Cities and Towns, prompted litigation in the 40s. They had actually lost a lawsuit in 41 where the Supreme Court had said that there wasn't the authority to impose for cities to pay dues to an organization such as the League. And they said it wasn't a gift clause problem, but it was an authority problem, which was another focus of a lot of these early cases can government really do this? In the White case in 48, and this is another case that you still see cited, they said dues payments, obviously, as you know, because of where we are today, didn't violate the gift clause. It serves a public purpose. And the public purpose language is still quoted. In public purpose, incapable of exact definition, changes to meet new developments and new conditions, better elucidated by examples, and it's going to change over time. And rests in judgment of the city council, and the judicial branch will not substitute its judgment unless the council's discretion is shown to have been unquestionably abused. And it cites Tombstone v. Messia, that case from the 20s about the ice house, in its public purpose discussion. And I think this basic framework, despite efforts to chip away at that discretion, has remained. Now the public purpose was obviously to make sure that people could get educated and understand the benefit from the exchange of information through the organization, and they accepted that, and that was enough to satisfy the gift clause. There was no critiquing of what's the value of how much of the dues and trying to price things out. Jumping ahead to the 70s, town of Gila Bend and Walled Lake Door, another case that is cited there, and I think Cameron might have mentioned it previously. That was about Gila Bend constructing a water line to a single business, and that did not violate the gift clause. There was no dispute that it was only to benefit that one business. And when you look at the record, that business, was probably going to leave if it didn't get its water line, but that was infrastructure. It served a public benefit, and that was the focus of the court's analysis there. And so no gift clause violation in that circumstance, even though it did only benefit that one business. Although, water line for fire prevention and all that, there's all, potential broader implications. Industrial Development Authority versus Pinal County. There was these IDA bonds to help the copper company purchase air pollution control facilities. Someone referenced this case earlier. It held protection of health by preventing pollution as a public purpose, and industrial development, it also acknowledged, is a public purpose, and so it didn't have any problem. So this did not violate the gift clause. Now, in context, what was this all about? This was all about helping the copper company, comply with new federal regulations that were going to cost some money, and so the state was helping them, was arguably subsidizing that compliance, but the court said that's fine. It served a public purpose. Also note along the way, and I didn't include cites to these, but other contexts in which gift clause challenges were raised, and this gives you a sense of the variety, but retirement was also the subject of gift clause challenges during this era, whether retirement benefits were gifts, and those, again, because there are public retirement systems that no, that's not a gift. You earn it while you're while you're working and it serves all these legitimate public purposes. And one of the retirement cases is cited in Schires, Yeasel v. Copens, that does have some consideration language there, looking at, saying, there needs to be some sort of quid pro quo. And in the retirement context, obviously, it's because public employers are doing their jobs. But just because you're continuing to get paid after retirement, that's part of the contract, that's part of the deal that's been struck. And so a lot of these things, like nationally, there were challenges to retirement systems. When there were challenges in Arizona, there were challenges to the League of Cities and Towns type fees in the 40s when our fees were challenged. So these are often not really in a vacuum. They're often parts of things that are going on nationally. So one of the most important things in the 70s is that we did develop a split of authority at the Court of Appeals over whether consideration was part of the analysis. We had the Heiner case, which involved a deed to a nonprofit hospital, and the court said no gift clause violation. That public benefit constitutes a valid and valuable consideration under the circumstances. So as long as there's a public benefit, you're going to be fine. It's not a gift. And then you had City of Tempe versus Pilot Properties. And there it was about baseball and building a baseball stadium. And there it said public purpose is not enough. There must be consideration that is not so inequitable and unreasonable that it amounts to abuse of discretion. So there you see kind of the development of more of the consideration type analysis we're seeing now. And if you look back at the Pilot Properties case, that was probably the beginning, I think, of more sophisticated gift clause litigation that involved a lot of, big players. It wasn't the Goldwater Institute. It was a lot of baseball teams and other folks who were concerned about that particular transaction and how it was playing out. And so we did get this split in authority in terms of whether there's a consideration requirement. So our Supreme Court, in a decision authored by Stanley Feldman, resolved that dispute in the 80s by saying they agreed with Pilot Properties. We have a two-part test. Does the agreement serve a public purpose? And is there sufficient consideration? And excuse the typo there, is the consideration far exceeded by the amount paid by the public? And again, they're talking mostly about payments here by the public in this context. The guidance given in Worcester was don't be overly technical, give appropriate deference to the findings of the governmental body, and the analysis should be based on a panoptic view of the facts. And in this case, it was about release time, teacher release time, and based on the record, it did not violate the gift clause. And the record there were basically declarations that were submitted to show, the contract and the value that the city thought it was getting from the agreement. And I think, as Cameron said, it was pretty simple, straightforward litigation. It bypassed the Court of Appeals and went to the Supreme Court to resolve the split between the Court of Appeals, and they did by adopting the two-prong test that we have now. So again, in our post-Worcester era, Cromco is one of the first decisions, again, another one that's still cited, and one that I think is worth thinking about in terms of how much of this you can draw from. That it concerned the conveyance of the U of A hospital to a nonprofit, and it was required that it had to remain a teaching hospital, and the base rental fee was $10 a year. The nonprofit was assuming a certain amount of debt, but also getting the land improvements equipment worth more than 57 million, no gift clause problem there. The court noted the monetary benefits to the state. There was also board control to maintain the educational relationship between the university and the hospital. So this issue of, and that's the Board of Regents there. So the issue of governmental control became sort of more part of the analysis than I think you see in some of the earlier cases. And the educational relationship, it noted, is a non-pecuniary benefit, but it is consideration. And I think this is important. And I think it's still good law in terms of the recognizing the non-pecuniary benefits were consideration, because here part of what they bargained for was to make sure that there was still going to be a teaching hospital. So there was no gift clause violation, but they didn't, again, turn it into just they didn't try to quantify everything. They looked at the agreement, laid it out, and said, this is okay. We also had one where there was a gift clause violation, where the legislature, to resolve a dispute about claims to riverbed lands, and excuse the typo there, violated the gift clause, where they were just trying to give this property away, and they said you can't do that. More process needs to be established to have a valuation. That was just a Court of Appeals decision, but one of the few in that era where there was actually a gift clause violation. Cameron talked about Cotterman v. Killian earlier, which was the tuition tax credit case. And most of it's about other things, in terms of state support for private school, those kinds of things. But there's a paragraph or a couple of paragraphs about the gift clause, and they lay out the purpose that we've already talked about, and said that this situation doesn't raise the same problems that the gift clause was designed to address. And the analysis is one can't make a gift of something one does not own. And so again, getting into the points that have been raised previously, that if you're dealing with tax credit issues or fee waiver issues, money that the city doesn't own, this is a case to look at. There were also, over the years, lots of, in this kind of post-Wistuber, pre-Turkin era, a series, lots of gift clause, AG opinions. And some of them are kind of interesting, and some of them are useful to look at because they address a lot of everyday issues that may come up, or random things that people are worried about. One, ticket purchasers, this would be I think the Sun Angel Foundation, whether you could make ticket purchasers trying to buy tickets to a football game at a state university, whether you could make them contribute to a booster foundation. AG's office says no. Can you have employee recognition programs that give awards of nominal value? Yeah, that's fine. Can you amend school employee contracts to incorporate special legislative appropriations? That's okay too. And can you allow charter schools to retain the property that they have purchased with state money? They said that was not facially a gift clause violation in an AG opinion in that post-Wistuber era. So the next major development is Turkin v. Gordon, 2010. Wistuber, again, was a Feldman decision. Now we get to an Andy Hurwitz decision. There was a dissent in Wistuber by Justice Corcoran, who would have found a violation. Turkin was a unanimous decision. The opening sentence there, this is one where you read the first sentence and you kind of know how they're going to feel about, how they feel about the issue. The issue for decision is whether an agreement by the city to pay a developer as much as $97.4 million for the use of garage parking spaces violates the gift clause. So you get a feel that they were not comfortable that $97.4 million was appropriate consideration for the parking garages. And they go through the analysis. Consideration cannot be so inequitable and unreasonable that it amounts to abuse of discretion. Again, that's from Wistuber. And then they look to contract law principles to explain consideration and indirect benefits. This is really the first time this concept is talked about. They say indirect benefits don't count for consideration when not bargained for, but they count for public purpose. And that, if you look back in the case law, that was not a distinction that was made. They really kind of often blended things that could be a public benefit, also supported consideration. And you see some of that in Kromko talking about the educational benefit. I think that's a public benefit, but it's also counts for consideration. But here they didn't contract for the indirect benefits. And that, at least when I read Wistuber, what are indirect benefits? The things you're not contracting for. And Turkin, when you look at it, different people pluck at different sentences, as you do with lots of opinions, and in terms of how they explain how the consideration analysis works. So there, again, it was basically a parking space agreement. There wasn't any dispute about public purpose. Government can negotiate for parking spaces. They find, they still hold to the deference to the judgments of the elected officials. But they were concerned that the payments here greatly exceeded what the government was going to be receiving in return. And here, even though the payments were conditioned on completion of construction of certain retail places, all the value here was, a lot of the value that they were claiming were these indirect benefits. And there wasn't evidence, they didn't think there was sufficient evidence to support the parking space agreement. Now they noted that in ordinary circumstances, they need to remand in light of its decision, but they decided they didn't need to do that in this case, or what they weren't going to do that in this case, because they acknowledged that people may have been confused since the decision in Wistuber and taken that panoptic view of the facts too far and were counting things that were really indirect benefits as part of the consideration evaluation. So they said, we're just going to give this guidance and we're not going to remand. And they also kind of give some historical perspective. And if you look back on, as I mentioned early on, we got our constitutional provision from Montana. Montana was a public purpose only analysis. And like Heiner, when Wistuber had that fork in the road, do I go with a consideration analysis or just a public purpose analysis? And Montana had gone the route of just the public purpose route. And then in the 70s, it reevaluated its constitution as a whole and eliminated its gift clause because they say that's really, we already have the protections for public purpose in other provisions, as we do in Arizona as well. And so part of the court's concern here was that they wanted to make sure the gift clause had meaning. It wasn't just redundant of our tax provision in our Constitution that requires that expenditures have a public purpose. We've talked some about footnote 4 from Turkin v. Gordon, which is important, that Turkin was dealing with contractual issues where they weren't dealing with non-contractual issues. The example they give is assistance to the needy. We're not sure how far, I'm not sure how far that example extends. So there's room to debate in the future. And Cheatham v. DeCiccio, another release time case, won't spend much time on that one, a 3-2 decision with dissenting justice. The people who dissent in that case are the only ones who remain on the court today, Justices Timmer and Brutinel. And I guess the important thing, although I wouldn't cite this case much anymore because of how the court has changed, but it analyzes consideration based on the contract as a whole, which makes a lot of sense, not based on any particular provisions in isolation. And I think that principle makes a lot of sense, but obviously not everyone felt like that was appropriate here. And it basically applies Turkin to the analysis. We have an AG opinion in last year on whether they're on COVID relief, and this doesn't get into the federal funds issues that others have mentioned, but just generally, whether school-related health expenditures were to families would violate the gift clause. Again, this gets into the range of issues that you kind of think, oh my gosh, this is going to raise gift clause issues. And there they said it doesn't. And they cite to Turkin footnote 4 in that analysis as well. And they give some parameters for how that might work in terms of when you're not going to have gift clause problems. So let's go to Schires, which is why everyone wants to talk about the gift clause right now. Again, that was an agreement with a private university to get it to open a branch campus offering certain degree programs in the city of Peoria. And they had to meet certain performance benchmarks, which were based on seated students in their programs. And the university was eligible for certain cost reimbursements up to a cap. And the city had to, Peoria, in addition, as part of opening a branch campus in Peoria, it had to invest, it had to spend at least $2.5 million on its campus there. And the maximum cost reimbursements payments that were available under this agreement were like $1.875 million. There was another agreement that was challenged under in the case that concerned the renovation of a building, and this again that would be used for the campus, and that was a matching funds arrangement as all. And this was part of an overall economic development program, both in terms of recruiting businesses to the community and in terms of the redevelopment of unused buildings in an important commercial area. And their evidence in the record showed that the university would not have opened a branch campus in the community without these incentives. There was also an exclusivity requirement that prohibited the university from opening any other community in the area within a certain period of time to, again, kind of protect the value that was being negotiated for. And there was a provision requiring that incentive payments be reimbursed if performance thresholds didn't continue to be met for a period of time. So these were post-performance cost reimbursement payments. And the trial court in this case and the Court of Appeals had upheld these payments. And then, as everyone knows, you get to the Supreme Court and they did not uphold the payments. And I think this is an example. When you get to the highest court, when you get to the Supreme Court, it's their case. It's their case. And they, and I think as an advocate at the Supreme Court, you do your very best job for your client, and, understanding the law, understanding, you do your very best job. But at the end of the day, it's their case, and they can tweak the rules, change the rules. They're not just looking at precedent and seeing how it applies, which is how everyone else in the system up until you get to them is looking at it. They're looking at the precedent to see how it applies in this case. But they get to change the rules, tweak the rules if they feel like it. And there might be, some debate as to, and they did that here. They did that here. And I would say they did that not just on public deference, but also on how they do the consideration analysis. But I understand, but they don't say they're doing it any differently. And I'll talk some about that. So how did the analysis work? Well, they said it serves the public purpose. And so there's no change in the law here. And this was a big, Goldwater put up a fight on this issue. And it sounds like in the Pima County case in the case Regina was discussing, they put up a fight on that issue. They were really pushing back on the concept of economic development as a legitimate public purpose. But the court did not accept that. And there's really no change, I think, in the law in how they approach that. But they did find inadequate consideration, and consideration includes direct benefits bargained for and does not include anticipated indirect benefits. I'll also mention in terms of the evidence, in addition to the direct investment that was required under the agreement, they had done a study when it was approved, that shows the anticipated benefits to the community that far exceed the investments that were made. But the court was concerned there was no promise to provide city goods or services or ownership interest in the campus or reduced tuition for city residents. So they saw they make those comments in critiquing the agreement. And they reject the economic analysis of the benefits that will accrue, and they reject even the direct investment as consideration. And the argument was, hey, the city has bargained for, and in the contract, the university, its promise is to open a branch campus in that city. And so the consideration question under Turkin, because that's what you've bargained for, is what is the value of that promise to the city? And the court didn't give it any value at all. And the place where I think it differs from the prior cases is that it comments that contract consideration can be different than gift clause consideration. And I think that's different than Turkin, because in Turkin, the court was saying, well, indirect benefits you didn't bargain for those, so those don't count as consideration. And they used the contract law framework for consideration, and they cited, contract law consideration cases. And consideration is the language of contract law, but they say in Schires that contract consideration can be different than gift clause consideration, which gets them off the hook for really attempting to value the promise to give the promise to open a branch campus in Peoria, and just say that doesn't have a value. And they accepted sort of the mantra of the elevator speech of, well, you're just paying a company to do what it does. And the argument to the contrary is, no, we want them to do this in our community, and they're not doing that. And this agreement is precisely bargained to get them to do that. And but they didn't give that any value at all under this agreement. They also, as Cameron had noted, rejected the deference to government on the consideration prong. There had been an argument by the Attorney General, actually, to get rid of the grossly disproportionate standard. They didn't do that. I don't think, and maybe that becomes less important when I think, have restricted sort of how you look at consideration, that not everything bargained for counts as consideration, and the no deference. And this part, I thought I would take issue with the drafting. I think they cite Cheatham for that principle and say, and they didn't, and sort of take a shot at Cheatham for saying, and they didn't cite any authority. Well, maybe Cheatham didn't, but that's a pretty well-established principle. When you look at the precedent, Cheatham didn't make that up. So again, they've eliminated deference, not on the public purpose prong, but on the consideration prong. And I think there's additional emphasis on documenting the specific benefits to the city, because there's one piece in there where one of the promises also was to participate in, from the university had an obligation to participate in economic development efforts, but those weren't spelled out in the agreement. So there wasn't a pricing it out, wasn't done by either party, but it was the Court of Appeals dissent would have remanded it for more analysis of that provision. And the Supreme Court says, well, that's hard to enforce, much less value, so we're not going to remand. We find the consideration here inadequate under the gift clause based on this analysis. And so there you have it. The other thing I wanted to talk about, so what's left? So we have Turk and footnote 4. That's still with us. I'm not sure how far that extends and how that will be applied in the future. It hasn't been applied, and but so that's an area that might be explored. I think it's a little scary because if not scary, but you know, when you have grant programs and you are if you are and it's not aimed at the needy, I'm not sure how far they'll go in extending this to other contexts, but we'll see. And maybe they'll just leave well enough alone in terms of what actually gets challenged. CROMCO, non-pecuniary benefits as consideration. I think that's real. I think that's still good law. But it's hard in a grossly disproportionate standard to figure out how much that adds to the equation and how to factor that in. Panoptic view of the facts. You will not see that phrase I did not see that phrase in Schires, and it's certainly not reflected in their analysis because they're like, no, we're not going to look at that. We're not going to look at that. You know, so I think it is more the technical analysis than we've had previously. And tax incentives and other things under Cotterman v. Killian, I think that's an area that you know would be developed. Peoria is different because that's a payment case. So the question of what's the next case, I think it's Reginas. Maybe not at the Supreme Court. We'll see what happens at the Court of Appeals. And but I think, you know, these come up every day for folks on a very practical level. And Schires, I mean, I think it does add another complication in terms of thinking about what we can do. And there's something to me that's a disconnect to say, yes, economic development is a public purpose, but then step back and say, and we're not going to count economic development, you know, we're not, but we're going to be very rigid in terms of how they evaluate the consideration here. And so, but as much as you can, you know, putting things in your agreement and thinking about how the court is approaching these is going to be really useful in the future. So that's my kind of walk through the gift clause. And if there are questions or Mike, whatever, we go from here.
Thanks so much, Mary. I see that there is at least one question in the Q&A, and it comes from an anonymous attendee. The question is, did Goldwater take a position on the Schires footnote 4? Specifically, would they argue that payments for the needy or for grant programs, et cetera, violate the gift clause?
They didn't. They haven't challenged payments to the needy. I don't think they're going to challenge payments to the needy because of the smart kind of case selection. It's worth so some of these things are, I think so I don't know how far that goes, and they haven't really taken that on here. Here, the argument definitely was that these weren't within that footnote because they were structured as agreements with obligations on either side. And I think most grant programs really do have obligations. And so that wasn't really an issue here, and certainly not the payments for the needy.
So the next question that came in, Mary, is to get your opinion on a question that was asked earlier about what about a city's expenditures to a Super Bowl committee or a similar type of expenditure?
Yeah, I agree with whoever commented previously. I'd want to see how they're structuring that. you're going to have to give that some thought and see, I would look at the part of Schires where they talk about, what are the residents getting out of this, and try and make sure that you have some stuff that you're getting back for your community and how you've structured that.
Right. And another question's come in from Sheila Schmidt. What is the rationale for not recognizing sales tax revenue that is generated from the economic development that you've bargained for as indirect benefits and not counting as consideration?
Yeah, that's a good question. And that goes back to Turkin to some extent, where those aren't really generated by virtue of the agreement, they're generated by operation of law. So those don't get to count. But it is a bit frustrating because it's like, well, if we're so limited in what they're money in the coffers, but you can't count them even on an economic development project, that one of the benefits of economic development is increased tax revenues. And so, but that's been the reasoning, that those are by operation of law. Now, maybe if you structure the agreement differently and say that you get these payments if you generate, X amount of tax revenue, maybe there's a different way to structure them. But those are all things to think about given the parameters that the court has established.
And I see Nancy jumping on. I bet she has her own question.
No, I don't have a question. I was just going to say, I was curious, Mary, if you had seen that the news stories, and I think there was a lawsuit filed in North Dakota about that. North Dakota's version of the gift clause, that the state used some of their CARES funds and gave them to these oil companies, which seems like a stretch in terms of giving to the needy, but I was curious if you had read about that.
I had not. That's interesting.
Yeah, I'll share the link in the chat because I'm curious if they actually did file a lawsuit or just threatening to do it, but it's 16 point something million that they gave to oil companies, which last time I checked, they weren't really very needy.
And just one random comment on oral argument. It was sort of a walk in the park for the Goldwater Institute here, where they would say things like, "Ooh, here's the answer to return," and nothing. But on the flip side, very aggressive questioning. And there was one point where Justice Timmer asked, where I was making my consideration argument, this is what you bargained for, particularly in terms of the investment that's required, that is more than any cost reimbursements that could ever be paid under the agreement. And Justice Timmer's question was, well, couldn't the consideration be different under the gift clause? And I'm like, no, it's not. It was, Turkin told us it's not. Turkin told us to follow the consideration for the gift clause, contract consideration. So, and that, comes through in the decision ultimately.
And I will say, if anyone wants to just see the climate of the Supreme Court, watching the oral arguments, Mary is very enlightening because, like Mary said, the other side, is very kind of just a very casual type of discussion with the court. Mary probably had like 5 words in, and there was already some significant interruptions and higher level of voice levels. So,
Mike, can I ask Mary one question before the break?
Please.
Okay, Mary, I thought I agree with almost every word you spoke. Do you agree that where Schires points is a situation where all this stuff has to be translated into dollar values? If you really wanted to litigate these, you'd need appraisers and economists to translate all this stuff into dollar terms, including stuff that's hard to value, like preferential admission for city residents, and then have a trial that's essentially a valuation trial. And if that happens, and the judge says, I believe this valuation and not that valuation, is that a fact determination that is reviewed for clear error?
That's a really interesting question. That's a really interesting question. I don't know how they're going to view, because they mentioned, you could have had, here are some other opportunities to benefit the citizens, but how do you fit that into this grossly disproportional framework? If not trying to value all that stuff, you're better if you try to get a value, but how do you do that? And yeah, and then does that turn this all to into more of a fact thing that goes to trial and are not summary judgment issues? I think that's right. I think that's right. I mean, to some extent, potentially, which is so different than the way these things have been litigated historically. Yeah, but so the more you can document it up front, the better off you're going to be, I think. I don't know. What do you think, Cameron?
Well, I don't know how you value this stuff. I mean, it's kind of nuts to me if you say, if we say, well, yes, we're opening a business and Goldwater loves this preferential for city resident stuff. It's kind of a fetish of theirs. But if you say we're going to give preferential hiring to residents of our municipality, how would you value that? You don't, the business isn't open yet. I mean, you're just picking numbers out of the air. But I think that's the logical consequence of this.
Yeah. And that's where I get a little frustrated to some extent, that if you're doing an economic development project that we know is public, why can't you just have a proper, honest kind of evaluation of what the bargains are, rather than sort of try and do this somewhat artificial valuation of like you're describing.
Well, yeah, I mean, what elected officials do all the time is make quality. This is the essence of a legislative determination, is letting you sort of count apples and oranges and say, for all these reasons, some qualitative, some quantitative, I think this is a good decision for our city. And to say it has to be reduced to dollars and cents, it's very strange to me.
And that's why I look back to Cromco, that acknowledges that non-pecuniary things can have value. But the problem is, how do you fit that into Schires when you're really trying to satisfy your burden of proof that it's not grossly disproportionate? And then you get sort of instead of, and they abolish the deference, then you're stuck with the court's reaction to what the value is of those non-pecuniary benefits. Mm-hmm. And that's why it's more appropriate to defer to the government officials, because it's really their job to make these decisions and they're accountable to the voters. But
well, we do have those judicial retention elections. So there's that.
I think Cameron and I could talk forever about this stuff.
I'm curious, Mary, too. I know the decision, and Cameron talked about the hamburger example. I know that I had a visceral reaction when I read the hamburger portion of the decision. I was curious if you wanted to share some thoughts about what you thought about this hamburger example, the hamburger chain.
I think it really missed the point of what's going on with this particular agreement. And that this is where there's in the record that this university would not have come but for these this agreement, and that's what matters here. What's the value of that promise? And yeah, you don't need to, and they didn't have an economic development plan that focuses on recruiting hamburger outlets, because you don't need that. This was for, targeted economic development opportunities. So I just felt like it was, I reacted like you did, Nancy.
Yeah, and also about maybe a couple words on that exclusivity contract or the exclusivity portion of the deal, kind of how the court treated that portion of that deal.
Well, kind of look back at that part of the opinion. I mean, none of that mattered to the court in terms of value.
And essentially, for those who haven't read the decision, and what it is and I might be saying it incorrectly, but I believe that part of the development agreement that the university agreed that it would not basically compete in any other municipality within, I think it was like the Maricopa County area or so forth. So it would kind of be exclusive to Peoria. And maybe I misunderstood it, but I think that's what it was. Yeah.
Yeah, that was part of the agreement, again, to protect the value.
Yes, that non-compete covenant was in the agreement, but it clearly didn't impress the court in terms of providing any benefit that actually counts as consideration. And they're making that distinction. You know, something that's a benefit isn't necessarily consideration, because this is a gift clause case, not a contract case, which I thought as municipalities, we have the power to contract just like other entities. So why doesn't it count? But I think it's time for our break before our last session. And let's.
I think there was one question though, but maybe I'm wrong. Maybe it's gone.
There was a
Ellen.
question posed in the chat.
Okay.
From Sterling Solomon, hello Sterling, that I think we'll address during the roundtable. So we'll get to it, Sterling. We'll come back, I guess, at about 11:13. Managed to keep my Wi-Fi connection during this past break, which is better than the first time around. So just want to check in if Chris, you're going to be ready to go here. Great.
Yep, I'm on. Thanks.
Thanks, Chris. So before we move into a roundtable discussion and a Q&A session at the end of this, this third session is going to feature Chris Camacho of GPEC, and as well as Bill Sims, who's the general counsel for the risk pool. So by way of introduction, Chris Camacho serves as the president and CEO at the Greater Phoenix Economic Council, GPEC, which GPEC is one of the longest serving public-private partnerships for economic development anywhere in our country. During Chris's tenure, GPEC has led the attraction of more than 400 companies, created more than 74,000 jobs, and $11 billion in capital investment in the Greater Phoenix area. Chris's role is to oversee the domestic and international business development and market strategies for GPEC, and he serves as GPEC's executive leader in community interactions. I'm going to go ahead and introduce Bill at this time too, so we can just move into his portion of it once Chris finishes up. And Bill, who I think many of you know, spent some time flying jets for the Air Force, but then he decided to try something a little more exciting. So he continued his public service by representing Arizona municipalities as an attorney. Bill currently is the attorney for 8 separate cities and towns in Arizona, and is the general counsel for the city and town insurance risk pool. In case you're wondering what Bill likes to do for fun, this is what he told me. He said that he has his most fun when he can help a city, town, or county attorney implement the guidance from their elected officials. So there you go, Bill. Bill has been a presenter at probably more league and other conferences and seminars than I can count. And I can tell all of you that he's one of the first people that any of us city attorneys goes to when we have a new or a difficult legal question and we want to get an opinion from someone whose opinion we trust and respect. So look forward to Bill's piece of this as well. So with that, Chris, thanks for being here, and you have the floor.
Excellent. Well, thank you, Mike. And I look forward to hearing Bill's comments as well. So he can either clean up my act or maybe I'll just serve as his undercard for today. So, yeah, I think Mary did a great job of giving an overview of the technical sides of of this legal opinion. And, it's clear to me, there's a couple key groups that are going to win coming out of this. There's going to need to be more legal recourse to discern what this actually means. Is there still a lot of holes in this? When I looked at the original opinion and got our legal team looking at this, the fact that I think the point was made earlier that we're characterizing the ability to bring a hamburger joint to a community in comparison to what, even in this case, a university or another kind of base industry user, just blows my mind. I mean, it's obvious that we have a lot of work to do to educate the broader market and even, the courts on what economic development is, and this but for clause. I mean, when I read this initially, and then we dove in a bit deeper, when we compete with other places across the country, notably other red states, so think of Utah, think of Texas, Idaho, we have the handcuffs on more than any other market in the United States when it comes to the use of economic development funds. And when we look at even, in Texas, for example, cities being able to levy specific sales tax collections for their use of whether it's infrastructure or the latitude for job creation, for attraction and retention of projects, I think it goes without saying that, we're in a position where we're walking up to the fight with one hand tied behind our back. There's no question. Now, what does this mean for all of us going forward? First and foremost, I think we need to make it clear that most transactions that we do as economic developers, so whether it's cities, county, GPAC working in partnership, most of these aren't done through, these development agreements with incentives. So in most cases, majority of the projects are due to the competitive operating environment, the access to the Southwestern markets, the labor profile, the infrastructure base. But with that said, there are deals that are multi-state, site searches, site evaluation process. And I'll talk about this a little bit later, but it underscores the need from my standpoint of infrastructure readiness. We used to have this conversation about shovel-ready sites about a decade ago. The reality today, if the city does not have a site with ready infrastructure that's ready today, not being planned for, but today, it gets crossed off the list. So all this debate that's happening even at the Capitol today about, reducing income tax and then the coinciding impacts to cities, which I think are being overlooked, that is what portends our ability to compete for future projects, future job creation deals, is our ability to place public infrastructure in the ground around future commerce planning. So to me, it's just, I think we have a hell of a lot of work to do to figure out, how to move forward from this. But that being said, most of the deals, that are done through, development agreement with incentives, they're very, very limited number overall. So can we pop up? I've got, I think, 4 or 5 slides I wanted to walk through, quickly. Can we pull those up, or is that on me to do that?
I can pull them up, and it'll take me a couple minutes, or
Okay.
you can share your screen.
Okay. If you want to pull them up, then what I'll do is I'll just kind of keep going on, kind of what I'm seeing from, from this actually. So I think, and, as it was shared by Mary in this case, a lot of the feedback that I'm garnering from cities, so we have 22 cities that are in our partnership here at GPAC. A lot of other cities outside Maricopa County reach out to us and are asking, what our response is to this particular case. And, there's no question that enforceable promise is going to be very important. The structure of the contractual agreement with the company being, considering investing here, and the jobs they're going to be creating, they're going to be producing, the direct and indirect and induced impacts, which is, I think, probably the most astonishing aspect of this legal ruling, was the disallowance of the impacts. And so I'm still honestly scratching my head. In economic development as a professional for 20 years, our job is to induce new tax revenue that further diversifies the economic base and also provides high quality job opportunities for citizens. And I know that's what, the cities and the elected officials at the local level, that's what it's all about. So if we're saying that provides no value in the rendering of this decision, I struggle with, how do we do future economic development deals? And what I would say, I'm getting feedback in across all of these communities is it's a wide continuum. So the interpretation of this ruling, I have those that are kind of in one cohort on one side saying, this ruling is spooked us a bit, and we're going to still go through an economic impact analysis third party, but we're probably going to be much more gun shy and probably stay in the lane of just base infrastructure as a reimbursable model and on one end. Go to the other end of the spectrum, and what I'm hearing is some of these city cohorts are saying it's almost business as usual. We're going to tighten up our development agreements from an enforceability perspective and that promise, but still going to move forward with the basis of economic development value, which again, I think we're going to be in a position where we're going to need further litigation to clarify, what this means. And I guess I struggle overarchingly with a couple things. One, the ideological purists that believe that deals just happen, projects just happen, companies just fall in our lap, and then cities are just giving these incentives to private sector enterprises just because every one of these projects we're having to compete with other places that have similar constructs on the book. So I just argue this purism that exists, this purist mindset, is just not reality. And I think the other argument I heard earlier that was given, I think Cameron mentioned this, is determining a value of a non-tangible asset or good or value to a community. I don't know how we actually get to a point where we can further fortify this legal opinion without further clarity on a valuation premise. So I think this opinion in kind of totality created more questions in my mind than it does clarity. And then the other attribute that I'm concerned about is the retroactive nature. So when a company is coming to Arizona and we're working out the project and we're in the process of competing for all these projects, and say one comes to a particular community, the fact that there's no immediate sunset clause on litigation, meaning there's no 30-day, 60-day review window. This can go on for 5-6 years and be rectified further in the courts well after this process has been finalized. That also will be a concern of future companies considering investing here. So I covered a lot of what I wanted to share today in these few slides, but let's go ahead, if you can, just advance to the third slide I think we've got here, because I do want to talk just a little bit about direct and induce. And now here's what we compete with. Places like Texas, which have a massive competes fund, we call it competes fund here in Arizona. They would have what's called an enterprise fund, the Texas Enterprise Fund, and these other places where they do jobs against the dollars that are provided, and those are a form of tax credits, cash, and a combination of items, and they're all against direct revenue impact. So everyone backs out the induced, everyone backs out in most cases the indirect value that job creates other indirect jobs. So like an Intel job is likely to create 5 other indirect jobs in the market. What we're talking about only are direct jobs. And the challenge that I foresee as well on these performance-based models is we've relied for years on the state's job training program, which is like a base program, much like base infrastructure is being provided by cities. That the job training benefit, which was a certain per dollar value to help these companies train up their workforce, is no longer in play. There was a tax a couple of years ago that was stripped and taken away, and that was the funding that went into the job training bank. Those no longer exist. So what's happened in the last 3 years, our cities have taken on that responsibility to help train up the broader hires to help these companies onboard their staff and then ultimately do the on-the-job training. That in and of itself is something I'm hearing debated within the city continuum of, is that going to be allowable now? Will that be challenged legally in courts in the future? And I will tell you, when I say the one hand behind our back, job training, much like public infrastructure, are the basics. So you take that out, you're just giving our market more of a competitive, less edge, more of a round edge, not being able to compete. So I think that's a really important component of these decisions. It's leading to ambiguity as to whether the cities can actually move forward with these performance-based approaches. So let's go ahead to the next one, to infrastructure. One of the other things I talked about, briefly, and this looks like the most simplistic deck we've ever put together, but water, wastewater, rail, these innovation pilots, like a mobility pilot that we did with the Connective as part of Partnership for Economic Innovation for the Electromechanica deal. these kind of X factor opportunities where you're unifying the market around this mobility pilot, these things are going to be harder and harder to do because of the ambiguity of this ruling. And again, the cities, that wide continuum, while I don't think it necessarily makes sense to have an exact science on the consistency of application, I do hope that we generate a more consistent approach to what we do and how we do economic development program support in terms of making them performance-based, and a general kind of conception of how we, in a semi-uniform way, advance these uses, as opposed to having a across the board wide variety selection, because I'm concerned what that's going to lead to over time: further litigation, further ambiguous interpretations that then, does it further nullify or hamstring our cities to being able to do this, at the end of the day, when again, every market we compete with has state, county, and local economic development programs to support the inducement or retaining of high wage jobs with the intent of diversifying the economic base. So go to my final slide if you would, and then I'll close it up here. So what we've talked through with our cities is really harshly defining the project scope. Let's firmly understand all of the inputs that go into jobs, capital investment, net new payroll, wages, all of the impacts that would be felt on the direct measurement. Not only does GPAC provide these impact analyses with our own third-party group who does this analysis, we're recommending each city go and have their third-party entity outside of the one that we do. So we've got concurrent third-party validation processes. We evaluate the net positive return on investment, which is still being highly debated. Again, the direct ROI just behooves me to think that that's not counted as an economic development value, but that there's some question marks as to whether that's overtly clear in the opinion. And then the impact of direct revenue being included in development agreement, but stated as ensuring it's performance-based. And we've operated from that fashion since I got here 13 years ago, that we never provide upfront funds. We're never giving a gross disproportionate benefit to a company. So those are all things that we've advised on in the past with our cities and working in concert with them. And again, I expect the majority of our cities are going to roll forward and keep putting these agreements together in a post-performance mechanism. And then, we'll continue to see if the state programs that we have, which are very competitive with other states, if those maintain their position of not getting litigated in the future. So that's a quick update from an economic development lens. I'm looking forward to hearing Bill's remarks and, his view on these items. So why don't I pause there and kick it back to Mike, or maybe we're just going to go straight to Bill. So thanks for the opportunity to share our thoughts today.
Thanks, Chris. Bill, if you're ready to roll, it goes to you.
It says it on a different participant. Let me try it. Okay, we got it. And poor Matt has had to explain all this to me. Oddly enough, my first slide starts with a quote from the gentleman who just spoke. And this concerns the impact of Schires. This quote really does follow what he just said. And he talks about how it could freeze governments into inaction and kneecapping Arizona's ability to compete. But the point of this slide and the three that follow is to suggest that the sky is not falling. These 4 slides really are at the end of a 40-slide deck that I gave to about 130 city, town, and county attorneys about a month ago, as I tried to grapple with all the very good lessons learned from the very expert speakers earlier this morning, as we city and town attorneys try to make this work. There's about 100 of you on this phone call or this Zoom right now. We have to take all the things that were just described and try to make it work for our elected officials. And this comes at a time when we have a stiff battle ahead of us. For example, the Goldwater Institute has authored legislation called the Minimized Crisis Cronyism Act. Under that statute, it will require all of us, 60 days after we pay a recipient of CARES Act funding or American Rescue Act funding, we have to post on our website how much we spent, who we gave it to, and what the criteria was. Why do you think they want that? Well, what I did in my presentation that we're going to use now to recap what we've been talking about is I tried to prepare some simple checklists to help city, town, and county attorneys tell their elected officials the sky isn't falling. First and foremost, take a lesson from Chris. Don't let the gift clause freeze you into inaction. There is a case that was referred to earlier, Navajo tribe. It dealt with the Department of Administration refused to make payments through DES for Phoenix and the Navajo tribe. And the court held correctly that if we're spending federal funds, it's a conduit. And if you're a simple conduit, the state constitutional requirement doesn't apply. The problem is that under CARES Act, we had our governor impose a number of restrictions. And so the question, restrictions only for the small cities and towns. There is a bit of relative sort of inequities here. I know Mike and Chris are on the phone. All you get to sit at the adults table. The rest of us sit at the children's table. But we were called in CARES Act, the funds had to go through the governor. He added additional requirements, and some said the conduit theory was lost. Thankfully, under the American Recovery Act, or Rescue Plan, I'm sorry, they have imposed absolutely no restrictions, although they continue to treat us smaller cities differently. The larger cities are called metropolitan cities. Everybody else were called non-entitlement cities. But the point is, relying on Navajo tribe, we can argue, we don't ever have to get to the gift clause. This is meant, do we follow the restrictions of CARES Act or the Rescue Plan Act? And we would say that the governor hasn't imposed any requirements, therefore we're free from the gift clause. Now, if you can't get around that, then now we're at what everybody's been talking about, Wisterber footnote 4 in the Turkin case, where we have non-contractual public expenditures. I think that is our best argument. But the problem is, what does supporting the needy mean? And our AG came online quickly with an AG opinion that was very helpful. Supporting the needy was quoted in Wisterber, quoted in Kromko, I'm sorry, and in Turkin. But the case I like the most to help us here is Kromko, and Mary described it well. I think we use Kromko to expand the supporting the needy to allow statutorily required community benefits through business and activities that indirectly support the needy. Cameron talked about somehow he thought a social program would be adequate consideration. I don't think that word alone works. I do think that the express comment in Turkin that said, it went on, it said that Kromko was valid consideration. I think they reached that conclusion because 1, there was a statute, and 2, there was a contract. And so when I walk through this with the other attorneys, I first say, follow the conduit argument. We're only spending federal funds, we never get to the Constitution. If we lose the conduit argument because the governor has imposed requirements, do support the needy and hug Kromko. Hug that footnote that Mary talked about in the Industrial Development Authority, where they even allowed pollution remedies to go through a company, and argue like Kromko that the amounts you're getting are being used. Now, one open question is, what is the needy? And that'll be defined. But if all that fails, we're then stuck with what the court gave us, but all's not lost. I truly think, and I'm always an optimist, I think we do 2 things. 1, we take them at their word. We divide the consideration into 2, for direct benefits and indirect benefits. Where I think Schires went too far is for what Cameron talked about, by rigidly imposing financial analysis as if this were a retail deal. What you do on the indirect, what you do is you go ahead and take them at their word. Economic development is fine. Go ahead and attach all the reports that you would normally attach to justify sales tax rebates, the 9-500.11. Get your consultants to do all that analysis to show under the statute that the taxes are greater, the benefits are greater, the benefits to the city or town are greater than what we're giving. That gets us the indirect benefits, but it doesn't get you all the way there. We now have the direct benefits. And I think Schires throws a big obstacle in that unless you take them at their word. You say the judge wants to measure consideration. Well, we're going to do that. We're going to list a whole variety of direct benefits and we're going to quantify them. We're going to put them in the contract. We're going to make a remedy. And we did this and the city attorney for this one jurisdiction, we did this for a whole hotel deal. We went ahead and negotiated the 9-511. We got the sales tax benefits and we attached the report. I think it's wise to attach the report because that sets the stage, sets the standard that at least we're getting 51% of the taxes. Then when we say to the developer, you know what? because of that Schires case, you don't get anything if we don't satisfy the Constitution. You've got to give us some hard-edged obligations. And guess what this jurisdiction did? We did a long list of them. It was a hotel deal. So we obligated the hotel to make the pool available for community swim. We obligated the hotel to give its conference centers available for free. We obligated the hotel to train local employees on the hospitality industry. We obligated the hotel at no cost to make the parking lot available for swap meets and farmers markets. We obligated the hotel to, this was a big one, to in effect give the city or town advertising. In this case, it was worldwide because it was on the border, and to promote the marketing of the jurisdiction. That has value. And what we say to the developer is, you don't give this to us, you're not going to get the sales tax. Go ahead and put these in the agreement. Read paragraph 21 of the Schires case. I think that stands for the proposition that you do need to have a contract. You do need to have a remedy. You do need to have the ability to enforce. And if you put that all in there, then I think you have both the direct benefits and the indirect benefits. Put them in the contract, get remedies. We went over, I tried to be over in time, but the bottom line is I'm not chagrined, but I am like the mechanic in the garage, like all the other city and town attorneys. We're sitting here trying to keep the engine running. We've got COVID dumping down on us outside. We've got the Supreme Court changing the rules of the road. And I agree with Cameron. I think the judicial deference is a problem. I like the idea to be able to say I made a record and my elected officials made the decision. Now we're going to invite judges into measuring consideration. I think that's wrong. But the point is, we're stuck with it. But what I do is I put in the recitals that we understand that's the case. We're going to have two various benefits. We are going to have indirect benefits, and we have a slam dunk, and we attach the report. And then for the indirect benefits, again, wink, wink, nod, nod to the developer. If you want to have the sales taxes, you better give us these benefits. And it really doesn't cost them much. They're going to do advertising anyway. And that gives us a number. We really followed from Regina's example. We looked at the worldview and we say, you know what? We need to be able to show that we have sufficient benefits so that accruing to the city or town, so that what the developer gets doesn't far exceed. And I think that isn't 5149. I think it's something closer to 7125, but that'll have to be tested in court. And this was the last slide that I had. The purpose of my presentation there and my purpose today is to compliment all of you on this phone call. I think local governments have stood the test well. I think notwithstanding very conflicting and varying guidance, we've done our jobs. The risk pools have pitched in, the league has pitched in, and we can protect our communities. You, the attorneys, play a significant role. Good luck. It's not easy. I try to get it fast, Mike. We're done.
Thanks, Bill. That was great. And I'm hoping that all of the speakers are going to stick around here for the last bit to help answer questions or to ask questions of one another. And I'll stick around for this part. If I can add any value, I'll jump in. And Nancy Davidson, the General Counsel for the League of Cities and Towns. And by the way, thank you to Nancy and to the League and to Matt Lohr in particular for doing the heavy lifting of putting this together as part of our overall summer CLE series for city and town attorneys. Thank you very much. So I think we did have the earlier question from Sterling about, these cases we've been talking about, they're all on the back end, right? After the fact, let's evaluate the agreement that cities or towns got into. But as the city or town attorney, what's the best way to advise your client at the front end in terms of, how to best position yourself? And Bill, I think you just ticked off the boxes on that. I think the only thing I would add to what the points that you already hit was to the extent that you can target your public investment, your public expenditure under the agreement into public infrastructure. Obviously, it's going to be public infrastructure that's benefiting the development. the purpose of the agreement. But if you're putting your money into the public infrastructure, that's something that I think is unassailable, including under Schires. So I will check the Q&A, see if there's anything else. I think that's the only one so far. There was a question in the chat, a question to you, Bill, about the advertising. What was the advertising piece that you were referencing in the hotel deal?
That actually was the most, having read paragraph 21 of Schires, that was the one where we actually could get some hard dollars. We went to the hotel chain and said, you're going to be advertising this jurisdiction. This jurisdiction is on the border. We would like you to obligate yourself to, in effect, put in public service announcements that would add to your advertising and could generate marketing for our jurisdiction. That has significant value. Now, the way we pitched it behind closed doors, it wouldn't be in a discoverable document, and I hope the Goldwater Institute isn't on the phone, is we say, you're going to have this in your budget anyway. So just tell it, we'll script the wrestling match. We're going to obligate you to spend what you're going to spend, and you're telling us you're going to spend, but we're only going to add a clause that says, and you're going to add public service announcements for this municipality. I think that gives us hard edge consideration that meets paragraph 21 of Schires. And frankly, sorry, go ahead.
No, I was going to say, I think another thing that Schires was hitting on was really like specifics of exactly what they're going to do. So building on, Bill's example, I think he's absolutely right, but you want to build in some details too, right, Bill, in terms of you're going to do this many announcements or.
Yes.
Yeah.
That's the only way you can get the consideration up. And the city attorney's office, she did a great job. They tabulated, we had a big number. And so, but what we've done is, I agree with you. I don't think we can say in the contract, this is the value. That's going to be challenged. But what we can say is they have a contractual obligation, and then we're going to have a spreadsheet showing what that consideration is. Then we're over the hurdle, which isn't the 5149 of a sales tax abatement. It is simply does not far exceed, does not abuse the discretion. And I'm hoping you're right. I liked your example on the 25%. Was that for foreclosures? Was that what it was? The 25%?
Yeah. So if you have a non-judicial sale, somebody can challenge it as being invalid if it's just grossly disproportional. And the standard that the courts have applied is a very low proportion, right? It's like 20%, 30%, something like that.
That alone made this presentation worth it. That helped me here. What you just said gave me a hook as to why 25% is a valid number. I was just making it up.
And I'm curious too about, because I know Mary was talking about the court not liking certain decisions, possibly, or at least hinting that they didn't like previous decisions. Cheatham is one of the ones that comes to mind, but it's curious if anyone had thoughts about how, if the public benefit as part of the consideration is to the public employees themselves. So like the use of a gym facility, or where an agreement allows for certain benefits to the city's employees, but not necessarily to the general public, how that would be treated by the court, and that in the context of Schires, but also in the context of the use of CARES funds or the American Rescue Plan to give like salary increases to public employees, like a stipend. I know a couple of cities have done that. I'm just curious on people's thoughts.
I'd be careful with that. The CARES Act and the Recovery Act has limits on what you can do with their funds for public employees. I think the minute you start broadening that, then you're right into the sights of Goldwater. And I totally agree with Cameron. When I advise the 70+ cities in the city town, it's best to stay in the middle of the herd. And so I think if you start using funds to pay employees, I think Goldwater could probably take a shot at you. Now,
I think in terms of, for example, somebody be giving discounts of some sort to public employees, right? If it would be an appropriate benefit, right, for the government employer to provide, like let's say the employer as part of its wellness program, regularly help subsidize employees' memberships, right, to a gym or something like that. Then if you have an entity that can provide that, right, that would be value.
I agree with that.
Our consideration, I apologize, wasn't just employees. It was primarily for when people come from out of town to attend government conferences. That was really our primary target. added to that, that if the room's available, then we can make it available to employees. But I truly think that would be a public purpose. That is people coming to this jurisdiction that is relatively in the middle of nowhere. And no offense to the attorney who's on the phone, and then letting them have rooms at a cheaper rate, I think is valid consideration.
So I'd be curious of the panelists, what you think the implications of the decision are to what I call GPLET. I know it's called GIPLET north of the Gila, GPLET transactions.
This is Cameron. Well, it's obviously Cameron. I don't think it applies. I mean, I know that the Superior Court disagreed in the City of Phoenix case, but it's a tax code issue. And I think there's just an argument that, you know, you can't start, we're already looking at a system where the judicial branch is going to superintend spending decisions. And I don't think we can go to a system where the judicial branch is now going to superintend revenue decisions. I mean, let's just, you know, why even have executive and legislative departments of government at that point?
And the legislature creates all sorts of different tax structures, right, to incentivize certain things. You know, if you have a federal trade zone, right, you get a very, very favorable property tax treatment for that. So the legislature does those kind of things all the time. And I agree, if you're going to start looking at every tax break or every tax consequence as a gift, that's not going to work.
No,
Well,
I completely agree. I don't think it applies because it isn't an expenditure.
Right.
It's exclusively on the revenue side. And to the extent that it would be argued that it does apply, I think we need to remember that the tax credit case, which is what Cotterman, and the language there about, well, you can't make a gift of something that you don't own in the first place, right? So if the legislature has established this alternative excise tax, but it only applies in certain circumstances, and we just follow what the legislature has provided, and in that tax structure, we haven't given away anything that we own, and we haven't expended anything, which I think is the key point.
I agree with that. And as Cameron referenced, I mean, at least one judge in Superior Court does not agree with that. But I think that's right. And I think Schires helps some on the tax piece because of its rejection of taxes on the government side. So it doesn't make sense to count it on the other side of the equation. And I think, Regina, in your case, I think that's how they use Schires as well. So I think. And
our argument was exactly what's good for the goose is good for the gander. If indirect benefits that flow from legal obligations don't count for the government, then they don't count for the private entity.
But in future litigation, your case tees that up, but I think that is still out there in terms of litigation issues and the viability of how much Cotterman applies in that context.
Mike, I have two sort of accumulated points that I have notes on. Chris Camacho mentioned a concern about reaching back, challenges reaching back and upsetting agreements that have been in place for several years, because a lot of agreements involve payments that go on for 5, 10, 20 years. And I've heard Chris express this concern in the past. I'm actually pretty confident that that can't happen. And you can make an argument that each year is a separate, like tax law treats every taxable year as a fresh start. I don't think that rule applies here. I think if you have an agreement that was put in place 10 years ago and there's a 20-year payout, I just don't think anybody's going to get much traction challenging year 11 under the gift clause. I think that a combination of, statute of limitations and estoppel and something else will get you there. And I know the Goldwater Institute tends to take that viewpoint. They don't want to run into a timeliness defense, and a motion to dismiss on square one. And they've always been careful to challenge fresh deals. The other point I want to make is the footnote 4 of Turkin, I've spent 10 years kind of thinking of that as, a special category of kind of this, nonprofits and social expenditures, and that kind of thing. And I'm kind of surprised at the amount of discussion I've heard today about kind of firing up footnote 4 as a response to Schires. And I'm intrigued by what Bill said, but to say I'm going to incentivize this big insurance company to come to my jurisdiction and they're going to build their headquarters and this is all falls within footnote 4. I don't know. I don't think so, but
I use footnote 4 to get me to paragraph 48 of Turkin.
Okay.
That really does expand on Cromco. And what it says in Cromco, have a statute, have a contract, and the social benefits that you broadly defined in your comments, which I don't think would survive consideration, is valid consideration. So the challenge is to try to get a use that tries to get closer to what is a statutory exception for hospitals. Now that won't help all your businesses, but I think it could have helped the university. I agree with you. I found offensive the way they equated a hamburger flipper with a university professor. And so what they should have done is what we did in this other jurisdiction, learning from Schires, is build the list, obligate the developer, have remedies, and then bring it back. But it's not footnote 4. It's paragraph 48 of Turkin.
Cameron, I wanted to just quickly bring up a point you raised, and I think Mary touched on it as well, is that the constitutional exemption for special districts or special taxing districts, you either have them or you don't. I can tell you that in Tucson, that's been an important piece for us because we have a multi-purpose facilities district, which is statutorily a special taxing district that falls within that constitutional exemption. And they've been an important piece of our economic development agreements that have occurred within the boundaries of that district. So they can be an important vehicle for some of these transactions that are, big economic development benefits within your city or town.
Yes, the Maricopa County Stadium District, back when they first built the Diamondback Stadium in the 1990s, there was a gift clause challenge. And the Superior Court ruled that no, the Maricopa County Stadium District is the gift clause doesn't apply. So, but I'm still, a lot of the time, just to do a sort of garden variety incentive deal, it's hard to use, your irrigation district to get there,
Right. And those districts have their own statutory limitations on the purposes for which they can expend their funds. So,
and Cameron, I was actually a county attorney at the time, and we were able to defeat that. But one thing you have to worry about when you have these alternate entities is to make sure the Title IX or Title 11 entity doesn't artificially control, so they become an instrumentality. Then you've lost the exception. So you got to be careful when you create these entities that you don't control them by the government, by the government that is subject to the Constitution.
Yeah, no, I said this was not a fully baked plan, and but it's out there.
And just Cameron, your point about Chris's comments about changing rules halfway and his concern. I think I can't speak for GPEC's position, but I do know that I think the rules are tough when they change halfway, when the agreement isn't signed yet. And you spend, it takes about, approximately 18 months from entitlements to digging in the ground. And it takes a lot longer before we start negotiating an agreement. So I think a lot of it too is not just once you have an agreement, it's you've been negotiating this agreement for over a year, and then Schires happens and you're like, oh, yeah, now the rules are changed. So I think from their perspective, they're so on the front end that their concerns are are probably more on changing the rules when you're trying to entice a lot of businesses, that first step to get them in. But that's just, I can't speak for GPEX. I don't know.
Yeah, I guess I wish we could get to a place where gift clause risk was conceptualized the way that referendum risk is conceptualized in zoning cases. That, you know, our clients know that your rezonings are subject to referendum, but that is a, you know, it's a theoretical risk, but they know when it will happen and what it will look like and when the risk evaporates. And when you have those parameters down, you deal with it. And it's, anyway, I wish the gift clause were like that.
I also wish that the state would stop adopting laws that prohibit us from charging for reasonable use of our right-of-ways, which is a complete violation of the gift clause in my personal opinion. But this legislation at the federal and state level that keeps taking our rights away to charge for what should be charged and not be a gift to private telecommunications companies. But that's my 5 cents worth.
My wish was back to Wistaber or Turkin, but they had just gone with the public purpose test and not gone down this path of consideration, because it's a mess and it doesn't really work for a lot of what government does. And it works for goods and services, and gone the path of other jurisdictions who just look at it as, and as we did for a lot of time, just look at it for public purpose. But that's obviously not where we are. We're now with a pretty you know, strong consideration test. But that was my wish under gift clause.
Okay. Well, I share your wish, Mary.
I mean, that's how government should work. And then the government officials are accountable, and, you know, it's maybe not, I know it's not where we are, but Feldman had a chance, Hurwitz had a chance. They didn't go there.
I'm still wondering how a football coach is worth a $3 million a year salary if indirect benefits are irrelevant. That if the only thing you're allowed to pay a salary for is the skills of a football coach, it shouldn't be worth that much. But
well, as a professor, maybe you should challenge such a thing.
Fair market value, fair market value.
Well, thanks, everybody. I don't think we could have had a better series of speakers here today, and I'm pretty confident that the folks watching got their money's worth for sure today. So, Nancy, unless there's anything else, I think it's about that time.
Yes, thanks, Mike, for everything. Thank you for all the speakers and for everyone participating. Really appreciate it.
thank you.
Thanks for inviting us.
Thanks all.
Thank you.
Take care.